Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion from City of Austin v. Reagan National Advertising of Austin, LLC. In this case, the court considered this issue: does the Austin City Code's distinction between on-premise signs, which may be digitized, and off-premise signs, which may not, constitute facially unconstitutional content-based regulation? The case was decided on April 21, 2022, in favor of the City of Austin. Justice Sotomayor delivered the opinion of the court, in which Chief Justice Roberts and Justices Breyer, Kagan, and Kavanaugh joined. Justice Breyer filed a concurring opinion. Justice Alito filed an opinion concurring in the judgment in part and dissenting in part. Justice Thomas filed a dissenting opinion, in which Justices Gorsuch and Barrett joined. These opinions are presented here in their entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Sotomayor delivered the opinion of the court. Like thousands of jurisdictions around the country, the City of Austin, Texas regulates signs that advertise things that are not located on the same premises as the sign, as well as signs that direct people to off-site locations. These are known as off-premises signs, and they include, most notably, billboards. The question presented is whether, under this court's precedents interpreting the Free Speech Clause of the First Amendment, the city's regulation is subject to strict scrutiny. We hold that it is not. American jurisdictions have regulated outdoor advertisements for well over a century. By some accounts, the proliferation of conspicuous patent medicine advertisements on rocks and barns prompted states to begin regulating outdoor advertising in the late 1860s. As part of this regulatory tradition, federal, state, and local governments have long distinguished between signs, such as billboards, that promote ideas, products, or services located elsewhere and those that promote or identify things located on site. For example, this court in 1932 reviewed and approved a Utah statute that prohibited signs advertising cigarettes and related products, but allowed businesses selling such products to post on-site signs identifying themselves as dealers. On-off-premises distinctions, like the one at issue here, proliferated following the enactment of the Highway Beautification Act of 1965. In the act, Congress directed states receiving federal highway funding to regulate outdoor signs in proximity to federal highways, in part by limiting off-premises signs. Under the act, approximately two-thirds of states have implemented similar on/off-premises distinctions. The city represents, and respondents have not disputed, that tens of thousands of municipalities nationwide have adopted analogous on/off-premises distinctions in their sign codes. The City of Austin is one such municipality. The city distinguishes between on-premises and off-premises signs in its sign code, and specially regulates the latter, in order to protect the aesthetic value of the city and to protect public safety. During the time period relevant to this dispute, the city's sign code defined the term off-premise sign to mean a sign advertising a business, person, activity, goods, products, or services not located on the site where the sign is installed, or that directs persons to any location not on that site. This definition was materially analogous to the one used in the Federal Highway Beautification Act and many other state and local codes referenced above. The code prohibited the construction of any new off-premises signs, but allowed existing off-premises signs to remain as grandfathered nonconforming signs. An owner of a grandfathered off-premises sign could continue or maintain it at its existing location and could change the face of the sign, but could not increase the degree of the existing nonconformity, change the method or technology used to convey a message, or increase the illumination of the sign. By contrast, the code permitted the digitization of on-premises signs. Respondents: Reagan National Advertising of Austin, LLC, and Lamar Advantage Outdoor Company, L.P. are outdoor advertising companies that own billboards in Austin. In April and June of 2017, Reagan sought permits from the city to digitize some of its off-premises billboards. The city denied the applications. Reagan filed suit against the city in state court alleging that the code's prohibition against digitizing off-premises signs, but not on-premises signs, violated the Free Speech Clause of the First Amendment. The city removed the case to federal court, and Lamar intervened as a plaintiff. After the parties stipulated to the pertinent facts, the district court held a bench trial and entered judgment in favor of the city. As relevant, the court held that the challenged sign code provisions were content-neutral under Reed v. Town of Gilbert. The court explained that the on/off-premises distinction did not impose greater restrictions for political messages, religious messages, or any other subject matter, and did not require a viewer to evaluate the topic, idea, or viewpoint on the sign. Instead, it required the viewer only to determine whether the subject matter is located on the same property as the sign. The court therefore held that the distinction was a facially content-neutral regulation based on location. The court further found no evidence in the record that the city had applied the sign code provisions differently for different messages or speakers, or that its stated concern for aesthetics and safety was pretext for any other purpose. Accordingly, the court reviewed the city's on/off-premises distinction under the standard of intermediate scrutiny applicable to content-neutral regulations of speech. The court found that the distinction satisfied this standard. The Court of Appeals reversed. The court opined that because the city's on/off-premises distinction required a reader to inquire who is the speaker and what is the speaker saying, both hallmarks of a content-based inquiry, the distinction was content-based. It reasoned that the fact that a government official has to read a sign's message to determine the sign's purpose is enough to render a regulation content-based and subject it to strict scrutiny. The court acknowledged that its interpretation of read was broad, but reasoned that the consequences were not unforeseen, given the concerns raised by justices who did not join the opinion of the court. Because the Court of Appeals determined that the city's on/off-premises distinction imposed a content-based restriction on speech, it reviewed that distinction under the onerous standard of strict scrutiny. Recognizing that strict scrutiny is, understandably, a hard standard to meet and that it leads to almost certain legal condemnation, the court held that the city's justifications for the distinction could not meet that standard, rendering it unconstitutional. This court granted certiorari. A regulation of speech is facially content-based under the First Amendment if it targets speech based on its communicative content, that is, if it applies to particular speech because of the topic discussed or the idea or message expressed. The Court of Appeals interpreted read to mean that if a reader must ask, who is the speaker and what is the speaker saying to apply a regulation, then the regulation is automatically content-based. This rule, which holds that a regulation cannot be content-neutral if it requires reading the sign at issue, is too extreme an interpretation of this court's precedent. Unlike the regulations at issue in Read, the city's off-premises distinction requires an examination of speech only in service of drawing neutral, location-based lines. It is agnostic as to content. Thus, absent a content-based purpose or justification, the city's distinction is content-neutral and does not warrant the application of strict scrutiny. The Read court confronted a very different regulatory scheme than the one at issue here, a comprehensive sign code that singled out specific subject matter for differential treatment. The town of Gilbert, Arizona, had adopted a code that applied distinct size, placement, and time restrictions to 23 different categories of signs. The court focused its analysis on 3 categories defined by whether the signs displayed ideological, political, or certain temporary directional messages. The code gave the most favorable treatment to ideological signs, defined as those communicating a message or ideas for non-commercial purposes with certain exceptions. It offered less favorable treatment to political signs, defined as those designed to influence the outcome of an election. Most restricted of all were temporary directional signs relating to a qualifying event, with qualifying events defined as gatherings sponsored, arranged, or promoted by a religious, charitable, community service, educational, or other similar non-profit organization. The Read court determined that these restrictions were facially content-based. Rejecting the contention that the restrictions were content-neutral because they did not discriminate on the basis of viewpoint, the court explained, "It is well established that the First Amendment's hostility to content-based regulation extends not only to restrictions on particular viewpoints, but also to prohibition of public discussion of an entire topic." Applying these principles, the court reasoned that a speech regulation targeted at specific subject matter is content-based even if it does not discriminate among viewpoints within that subject matter. For example, a law banning the use of sound trucks for political speech, and only political speech, would be a content-based regulation, even if it imposed no limits on the political viewpoints that could be expressed. By treating ideological messages more favorably than political messages, and both more favorably than temporary directional messages, the town's sign code likewise singled out specific subject matter for differential treatment, even if it did not target viewpoints within that subject matter. In this case, enforcing the city's challenged sign code provisions requires reading a billboard to determine whether it directs readers to the property on which it stands or to some other, off-site location. Unlike the sign code at issue in Read, however, the city's provisions at issue here do not single out any topic or subject matter for differential treatment. A sign's substantive message itself is irrelevant to the application of the provisions. There are no content discriminatory classifications for political messages, ideological messages, or directional messages concerning specific events, including those sponsored by religious and non-profit organizations. Rather, the city's provisions distinguish based on location. A given sign is treated differently based solely on whether it is located on the same premises as the thing being discussed or not. The message on the sign matters only to the extent that it informs the sign's relative location. The on/off premises distinction is therefore similar to ordinary time, place, or manner restrictions. Reed does not require the application of strict scrutiny to this kind of location-based regulation. This court's First Amendment precedents and doctrines have consistently recognized that restrictions on speech may require some evaluation of the speech and nonetheless remain content neutral. Most relevant here, the First Amendment allows for regulations of solicitation, that is, speech requesting or seeking to obtain something or an attempt or effort to gain business. To identify whether speech entails solicitation, one must read or hear it first. Even so, the court has reasoned that restrictions on solicitation are not content-based and do not inherently present the potential for becoming a means of suppressing a particular point of view, so long as they do not discriminate based on topic, subject matter, or viewpoint. Thus, in 1940, the court invalidated a statute prohibiting solicitation for religious causes but observed that states were free to regulate the time and manner of solicitation generally, in the interest of public safety, peace, comfort, or convenience. Decades later, the court reviewed just such a time, place, and manner regulation restricting all solicitation at the Minnesota State Fair, as well as all sale or distribution of merchandise, to a specific location. The state had applied the restriction against a religious practice that included soliciting donations for the support of the Krishna religion. As a result, members of the religion were free to roam the fairgrounds and discuss their beliefs, but they were prohibited from asking for donations for their cause outside of a designated location. The court upheld the state's application of this restriction as content neutral, emphasizing that it applied even-handedly to all who wished to solicit funds, whether for commercial or charitable reasons. Consistent with these precedents, the court has previously understood distinctions between on-premises and off-premises signs, like the one at issue in this case, to be content neutral. In 1978, the court summarily dismissed an appeal for want of a substantial federal question where a state court had approved of an on/off-premises distinction as a permissible time, place, and manner restriction under the Free Speech Clause. 3 years later, the court upheld in relevant part an ordinance that prohibited all off-premises commercial advertising but allowed on-premises commercial advertising. The Metro Media Court did not need to decide whether the off-premises prohibition was content-based, as it regulated only commercial speech and so was subject to intermediate scrutiny in any event. Shortly thereafter, however, the court applied the relevant portion of Metro Media and described the off-premises prohibition as a content-neutral prohibition against the use of billboards. Underlying these cases and others is a rejection of the view that any examination of speech or expression inherently triggers heightened First Amendment concern. Rather, it is regulations that discriminate based on the topic discussed or the idea or message expressed that are content-based. The sign code provisions challenged here do not discriminate on those bases. Reagan does not claim Reed expressly or implicitly overturned the precedents discussed above. Its argument relies primarily on one sentence in Reed recognizing that some facial distinctions based on a message are obvious, defining regulated speech by particular subject matter, and others are more subtle, defining regulated speech by its function or purpose. Seizing on this reference, Reagan asserts that the city's sign code defines off-premises signs based on their function or purpose. It asks the court to reaffirm that, where a regulation defines regulated speech by its function or purpose, it is content based on its face and thus subject to strict scrutiny. The argument stretches Reed's function or purpose language too far. The principle the Reed court articulated is more straightforward. While overt subject matter discrimination is facially content-based, for example, ideological signs, defined as those communicating a message or ideas for non-commercial purposes, so, too, are subtler forms of discrimination that achieve identical results based on function or purpose, for example, political signs defined as those designed to influence the outcome of an election. In other words, a regulation of speech cannot escape classification as facially content-based simply by swapping an obvious subject matter distinction for a function or purpose proxy that achieves the same result. That does not mean that any classification that considers function or purpose is always content-based. Such a reading of function or purpose would contravene numerous precedents, including many of those discussed above. Reed did not purport to cast doubt on these cases. Nor did Reed cast doubt on the nation's history of regulating off-premises signs. Off-premises billboards of the sort that predominate today were not present in the founding era, but as large outdoor advertisements proliferated in the 1800s, regulation followed. As early as 1932, the court had already approved a location-based differential for advertising signs. Thereafter, for the last 50-plus years, federal, state, and local jurisdictions have repeatedly relied upon on/off-premises distinctions to address the distinct safety and aesthetic challenges posed by billboards and other methods of outdoor advertising. The unbroken tradition of on/off premises distinctions counsels against the adoption of Reagan's novel rule. Tellingly, even today's dissent appears reluctant to embrace the read the sign rule adopted by the court below. Instead, the dissent attacks a straw man. Contrary to its accusations, we do not nullify Read's protections, resuscitate a decision that we do not cite, or fashion a novel specificity test simply by quoting the standard repeatedly enunciated in Read. Nor do we cast doubt on any of our precedents recognizing examples of topic or subject matter discrimination as content-based. We merely apply those precedents to reach the common sense result that a location-based and content-agnostic on/off premises distinction does not, on its face, single out specific subject matter for differential treatment. It is the dissent that would upend settled understandings of the law. Where we adhere to the teachings of history, experience, and precedent, the dissent would hold that tens of thousands of jurisdictions have presumptively violated the First Amendment, some for more than half a century, and that they have done so by use of an on/off premises distinction this court has repeatedly reviewed and never previously questioned. For the reasons we have explained, the Constitution does not require that bizarre result. This court's determination that the city's ordinance is facially content neutral does not end the First Amendment inquiry. If there is evidence that an impermissible purpose or justification underpins a facially content-neutral restriction, for instance, that restriction may be content-based. Moreover, to survive intermediate scrutiny, a restriction on speech or expression must be narrowly tailored to serve a significant governmental interest. The parties dispute whether the city can satisfy these requirements. This court, however, is a court of final review and not first view, and it does not ordinarily decide in the first instance issues not decided below. In particular, when we reverse on a threshold question, we typically remand for resolution of any claims the lower court's error prevented them from addressing. Because the Court of Appeals did not address these issues, the court leaves them for remand and expresses no view on the matters. For these reasons, the judgment of the Court of Appeals for the Fifth Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Alito, concurring in the judgment in part and dissenting in part. I agree with the majority that we must reverse the decision of the Court of Appeals holding that the provisions of the Austin City Code regulating on and off premises signs are facially unconstitutional. The Court of Appeals reasoned that those provisions impose content-based restrictions and that they cannot satisfy strict scrutiny, but the Court of Appeals did not apply the test that must be met before a law is held to be facially unconstitutional. Normally, a plaintiff bringing a facial challenge must establish that no set of circumstances exists under which the law would be valid, or show that the law lacks a plainly legitimate sweep. A somewhat less demanding test applies when a law affects freedom of speech. Under our First Amendment overbreadth doctrine, a law restricting speech is unconstitutional if a substantial number of its applications are unconstitutional, judged in relation to the statute's plainly legitimate sweep. In this case, the Court of Appeals did not apply either of those tests, and it is doubtful that they can be met. Many, and possibly the great majority, of the situations in which the relevant provisions may apply involve commercial speech, and under our precedents, regulations of commercial speech are analyzed differently. It is also questionable whether those code provisions are unconstitutional as applied to most of respondents' billboards. It appears that most if not all of those billboards are located off premises in both the usual sense of that term, and in the sense in which the term is used in the Austin Code. The record contains photos of some of these billboards, and all but one appears to be located on otherwise vacant land. Thus, they are clearly off-premises signs, and because they were erected before the enactment of the code provisions at issue, the only relevant restriction they face is that they cannot be digitized. The distinction between a digitized and non-digitized sign is not based on content, topic, or subject matter. Even if the message on a billboard were written in a secret code, an observer would have no trouble determining whether it had been digitized. Because the Court of Appeals erred in holding that the code provisions are facially unconstitutional, I agree that we should reverse that decision. On remand, the lower court should determine whether those provisions are unconstitutional as applied to each of the billboards at issue. Today's decision, however, goes further and holds flatly that the sign code provisions challenged here do not discriminate on the basis of the topic discussed or the idea or message expressed, and that categorical statement is incorrect. The provisions defining on and off premises signs clearly discriminate on those grounds, and at least as applied in some situations, strict scrutiny should be required. As the court notes, under the provisions in effect when petitioners' applications were denied, a sign was considered to be off premises if it advertised, among other things, a person, activity, or service not located on the site where the sign is installed or if it directed persons to any location not on that site. Consider what this definition would mean as applied to signs posted in the front window of a commercial establishment, say, a little coffee shop. If the owner put up a sign advertising a new coffee drink, the sign would be classified as on premises, but suppose the owner instead mounted a sign in the same location saying, "Contribute to X's legal defense fund or free COVID tests available at Y pharmacy or attend city council meeting to speak up about Z." All those signs would appear to fall within the definition of an off-premises sign and would thus be disallowed. Providing disparate treatment for the sign about a new drink and the signs about social and political matters constitutes discrimination on the basis of topic or subject matter. The code provisions adopted in 2017 are worded differently, but the new wording may not rule out similar results. For these reasons, I would simply hold that the provisions at issue are not facially unconstitutional, and I would refrain from making any broader pronouncements. Justice Breyer, concurring. Reed v. Town of Gilbert, is binding precedent here. Given that precedent, I join the majority's opinion. I write separately because I continue to believe that the court's reasoning in Reed was wrong. The court there struck down a city's sign ordinance under the First Amendment. It wrote that the First Amendment requires strict scrutiny whenever a regulation targets speech based on its communicative content. It therefore concluded that content-based laws are presumptively unconstitutional and may be justified only if the government proves that they are narrowly tailored to serve compelling state interests. But the First Amendment is not the tax code. Its purposes are often better served when judge-made categories, like content discrimination, are treated, not as bright-line rules, but instead as rules of thumb. And, where strict scrutiny's harsh presumption of unconstitutionality is at issue, it is particularly important to avoid jumping to such presumptive conclusions without first considering whether the regulation at issue works harm to First Amendment interests that is disproportionate in light of the relevant regulatory objectives. Here, I would conclude that the City of Austin's regulation of off-premises signs works no such disproportionate harm. I therefore agree with the majority's conclusion that strict scrutiny and its attendant presumption of unconstitutionality are unwarranted. The majority reaches this conclusion by applying Reed's formal framework, as stare decisis requires. I would add that Reed's strict formalism can sometimes disserve the very First Amendment interests it was designed to protect. The First Amendment helps to safeguard what Justice Holmes described as a marketplace of ideas. A democratic people must be able to freely generate, debate, and discuss both general and specific ideas, hopes, and experiences. They must then be able to transmit their resulting views and conclusions to their elected representatives, which they may do directly, or indirectly through the shaping of public opinion. Those representatives can respond by turning the people's ideas into policies. The First Amendment, by protecting the marketplace and the transmission of ideas, thereby helps to protect the basic workings of democracy itself. Courts help to protect these democratic values in part by strictly scrutinizing certain categories of laws that threaten to drive certain ideas or viewpoints from the marketplace. We have recognized, for example, that First Amendment values are in danger when the government imposes restrictions upon core political speech, when it discriminates against particular views taken by speakers on a subject, and, in some contexts, when it removes an entire topic of discussion from public debate. But not all laws that distinguish between speech based on its content fall into a category of this kind. That is in part because many ordinary regulatory programs may well turn on the content of speech without posing any realistic possibility that official suppression of ideas is afoot. Those regulations, rather than hindering the ability of the people to transmit their thoughts to their elected representatives, may constitute the very product of that transmission. The U.S. Code, as well as its state and local equivalents, is filled with regulatory laws that turn, often necessarily, on the content of speech. Consider laws regulating census reporting requirements, securities-related disclosures, copyright infringement, labeling of prescription drugs, or consumer electronics, highway signs, tax disclosures, confidential medical records, robocalls, workplace safety warnings, panhandling, solicitation on behalf of charities, signs at petting zoos, and many more. If Reed is taken as setting forth a formal rule that courts must strictly scrutinize regulations simply because they refer to particular content, we have good reason to fear the consequences of that decision. One possibility is that courts will strike down entirely reasonable regulations that reflect the will of the people. If so, the court's content-based line drawing will substitute judicial for democratic decision-making and threaten the ability of the people to translate their ideas into policy. A second possibility is that courts instead will, perhaps unconsciously, dilute the stringent strict scrutiny standard in an effort to avoid striking down reasonable regulations. Doing so would weaken the First Amendment's protection in instances where strict scrutiny should apply in full force. A third possibility is that courts will develop a matrix of formal subsidiary rules and exceptions that seek to distinguish between reasonable and unreasonable content-based regulations. Such a patchwork, however, may prove overly complex, unwieldy, or unworkable. And it may make it more difficult for ordinary Americans to understand the importance of First Amendment values and to live their lives in accord with those values. For these reasons, as I have said before, I would reject Reed's approach, which too rigidly ties content discrimination to strict scrutiny, and, consequently, to almost certain legal condemnation. Instead, I would treat content discrimination as a rule of thumb to be applied with what Justice Kagan has called a dose of common sense. Where content-based regulations are at issue, I would ask a more basic First Amendment question: does the regulation at issue work harm to First Amendment interests that is disproportionate in light of the relevant regulatory objectives? I believe we should answer that question by examining the seriousness of the harm to speech, the importance of the countervailing objectives, the extent to which the law will achieve those objectives, and whether there are other, less restrictive ways of doing so. The regulation at issue in this case is the City of Austin's Sign Code, which regulates billboards and other off-premises signs. The city defines an off-premises sign as a sign advertising a business, person, activity, goods, products, or services not located on the site where the sign is installed, or that directs persons to any location not on that site. Some years ago, the city forbade construction of new off-premises signs. At the same time, it grandfathered in existing off-premises signs, allowing them to remain but subjecting them to regulation. Owners of grandfathered off-premises signs are allowed to change the face of their signs, but not to digitize them. In the case before us, owners who wanted to digitize their off-premises signs challenged the city's regulation on the ground that it violates the First Amendment. The court remands for the lower courts to assess the constitutionality of this regulation in the first instance, so I need not answer that question conclusively now. I wish only to illustrate why I believe a strong presumption of unlawfulness is out of place here. Billboards and other roadside signs can generally be categorized as a form of outdoor advertising. Regulation of outdoor advertising in order to protect the public's interest in avoiding visual clutter, or minimizing traffic risks, is unlikely to interfere significantly with the marketplace of ideas. In this case, for example, there is no evidence that the city regulated off-premises signs in order to censor a particular viewpoint or topic, or that its regulations have had that effect in practice. There is consequently little reason to apply a presumption of unconstitutionality to this kind of regulation. Without such a presumption, I would weigh the First Amendment harms that a regulation imposes against the regulatory objectives that it serves. The city's regulation here appears to work at most a limited, niche-like harm to First Amendment interests. Respondents own a number of grandfathered off-premises signs. They can use those signs to communicate whatever messages they choose. They complain only that they cannot digitize the signs, which would allow them to display several messages in rapid succession. Perhaps digitization would enable them to make more effective use of their billboard space. But their inability to maximize the use of their space in this way is unlikely to meaningfully interfere with their participation in the marketplace of ideas. At the same time, the city has asserted a legitimate interest in maintaining the regulation. As I have said, the public has an interest in ensuring traffic safety and preserving an aesthetically pleasing environment. This page, and the city here, has reasonably explained how its regulation of off-premises signs in general, and digitization in particular, serves those interests. Amici tell us that billboards, especially digital ones, can distract drivers and cause accidents. They add that on-premises signs are less likely to cause accidents. The city further says that billboards cause more visual clutter than on-premises signs because the latter are typically small in size and integrated into the premises. I would leave for the courts below to weigh these harms and interests, and any alternatives, in the first instance, without a strong presumption of unconstitutionality. Justice Thomas, with whom Justice Gorsuch and Justice Barrett join, dissenting. In Reed v. Town of Gilbert, we held that a speech regulation is content-based, and thus presumptively invalid, if it draws distinctions based on the message a speaker conveys. Here, the City of Austin imposes special restrictions on off-premises signs, defined as signs that advertise a business, person, activity, goods, products, or services not located on the site where the sign is installed, or that direct persons to any location not on that site. Under Reed, Austin's off-premises restriction is content-based. It discriminates against certain signs based on the message they convey, e.g. whether they promote an on- or off-site event, activity, or service. The court nevertheless holds that the off-premises restriction is content-neutral because it proscribes a sufficiently broad category of communicative content and, therefore, does not target a specific topic or subject matter. This misinterprets Reed's clear rule for content-based restrictions and replaces it with an incoherent and malleable standard. In so doing, the majority's reasoning is reminiscent of this court's erroneous decision in Hill v. Colorado, which upheld a blatantly content-based prohibition on counseling near abortion clinics on the ground that it discriminated against an extremely broad category of communications. Because I would adhere to Reed rather than echo Hill's long discredited approach, I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. If you would like to support my efforts to make Supreme Court opinions available to the public, please go to the podcast's website. It's at anchor.fm/SCOTUS-opinions/support. Again, the website address is anchor.fm/SCOTUS-opinions/support. There you can also see other episodes and send a message to me, the podcast's creator. Thank you.